Good afternoon, everyone. It is with great pleasure to be here today with all of you and to address you on the topic of the linkages between judicial integrity and judicial well-being. I am Tatiana Veres, and I work as Crime Prevention and Criminal Justice Officer at UNODC, where I coordinate the activities of the Global Judicial Integrity Network. And because the topic of today's last session is judicial well-being, and I can imagine that as we are nearly at the end of today's insightful session, some of you may start to feel a little bit the effects of extended sitting. So please feel free to take a moment to sit up straight, relax your shoulders, take a deep breath, and a little bit have a moment of self-care to enhance your well-being. And as equally important is mental workout. For those of you who like mathematics, maybe you can do a little calculation in your mind. How much is 8 times 9? And for those who like double digits, maybe a bit more complicated, 11 times 12? Take a moment. So we often talk about judicial integrity, about the importance of fair and effective judicial systems and how to enhance the quality and fairness of decisions. But what is sometimes overlooked is also a crucial element, and that's the well-being of judges. It is seldom that we pause to reflect on the well-being of those who are entrusted with such an important responsibility to decide on cases of great consequences. But judges are human beings as well, and behind every judgment, there is a human who decides on the case. And if judges are expected to deliver decisions of highest quality and of high standards, to act ethically and to be trustworthy for the citizens who approach them, they should also be given conditions in which they feel supported and in which their well-being can thrive. And we started looking at the topic of judicial well-being after the pandemic, as we heard from many judges that they were experiencing challenges. But I would just like to emphasize that judicial well-being is not a new concept. And in fact, already the commentary on the Bangalore Principles of Judicial Conduct, which comes from 2007, already has a paragraph where it explicitly acknowledges the importance of well-being. And among others, it says that the judge should have sufficient time to permit the maintenance of physical and mental well-being. The stress of fulfilling judicial duties is increasingly being recognized. So promoting judicial well-being has the potential to strengthen judicial integrity and to lead to a fairer judicial system. And why? Why is that? So there are linkages. For example, on fairness, impartiality, and transparency. If judges experience high level of stress or burnout, this might undermine their ability to make fair and unbiased judgments, show the necessary empathy to case parties, and emotional exhaustion or fatigue may lead to stress-induced errors, lack of concentration, and inadvertent violations of ethical standards. With regard to effectiveness and accountability, we all know and also heard it today several times that justice delayed is justice denied. But if judges are overburdened and exhausted, struggling with backlogs and heavy workloads, this can indeed lead to delayed justice and take its toll on the quality of decisions, with judges rushing through cases and not being able to dedicate the necessary time they would need for a proper and detailed analysis and evaluation of cases. But also importantly, the topic of public trust is relevant. Reputation and public perception of the judiciary also depend on how judges behave. A stressed and overburdened judge might be not seen as impartial, might be seen less trustworthy, which might erode public trust in the judicial system. In the Global Judicial Integrity Network, we wanted to gain insights into concrete experiences of judges in this area and to learn more about what type of support and resources they would find helpful, and also what the judiciary could do to promote their well-being. You might have in fact come across our global report. It was published last year, and it analyzes responses received from over 750 judges from 102 countries. The report shines light on the daily experiences of judges, including the challenges they face, the support that they might be missing, and the possible actions by the judiciary that they would welcome. Some of the key findings of our report are the followings. 76% of judges participated in the survey feel that they do not have sufficient time to maintain their optimal mental or physical well-being. 92% indicate that the judicial work brings them stress. 69% feel that talking about mental health or stress is a taboo when it comes to judges and members of the judiciary. 83% say that the level of support available in their judiciary is not sufficient. And 97% think that more prominence should be given to promoting judicial well-being. You can all give it the moment to also think how you feel, how you would answer these questions, and how your judiciary supports you in this regard. But we wanted to look deeper. What are the reasons for such answers? And we wanted to look more at contributing factors to these high numbers. And the most common contributing factor appears to be excessive workloads. Many survey participants explain that excessive workloads are often a vicious circle where judges are under constant stress from excessive workloads, which in turn slows them down, which in turn causes them to take longer to process cases, and in fact creates further workloads. But there were also other contributing factors that the survey participants mentioned, and this included poor distribution of resources, lack of support staff, ineffective case management systems, competitive culture in the judiciary, lack of empathy among colleagues or from supervisors, lack of tolerance and respect in the judiciary, criticism and pressure by media and public and politicians, etc. We then wanted to look further at what types of support judges would welcome. And almost all survey participants, as I noted, 97% of participating judges, they believe that there is not enough awareness about the importance of judicial well-being in their judiciary. The concept of judicial well-being, unfortunately, continues to be unheard of in many judiciaries. And moreover, even in those judiciaries where there is some recognition, many survey participants explained the inadequacy and insufficiency of the available support and the continuing stigma and stereotyping around mental health issues. For example, in those judiciaries where support is available, but in a limited manner, some participants noted that there might be an occasional pamphlet on stress management or a one-time lecture on healthy nutrition, or some judges noted that the support might be available only in certain cities, but not really in rural areas, etc. So we found that although support is sometimes available, it might not be exactly what judges might need. And as a concrete example, one judge noted that he had to participate in 2 trainings on stress management, but they were so unpractical to him that ultimately it even caused him further stress because he had to delay his judicial work. So From the answers, it is clear that the concept should be looked at more closely and that judges might need really practical and helpful support in this. So what were some of the types of support that we identified as of use to judges? So first and foremost, many feel that even just a simple step of acknowledging the issue and showing understanding and compassion is a big step. That in particular, judicial leaderships should promote dialogue and should promote a safe space for judges to come together and to possibly discuss their issues. It is still a taboo in many judiciaries to speak about stress or mental health. There are certain stereotypes, and judges would often fear of being seen as weak or inadequate if they would say that they are struggling. But of course, there is also actual support that judges need. According to the survey, among the most needed forms of support are access to professional psychological counseling. And here again, it was emphasized many times that it should be trained professionals who also understand the specific stressors of the judicial office so that they can provide truly meaningful support. Then the value of peer support was repeatedly mentioned, such as mentoring, coaching, exercise classes, team building, nature trips, relaxation or mindfulness sessions, or anything that can help remove feelings of isolation and promote experience sharing. The survey participants would also welcome training that would be tailored to the different needs of different judicial roles, focusing on topics such as resilience, personal growth, or stress management. But again, it was emphasized that the training should be meaningful, practical, otherwise it would just be an extra work, an extra stressor. After the pandemic, we also saw the trend in finding useful, flexible working arrangements, which might help judges if they can, for example, work partially from home or have more flexible working hours, better holiday policies or parental support, etc. But there are also tools that maybe judges could be learned and would not require any additional resources, such as the concept of relatedness, trying to understand each other and emphasize, or mindful judging, and we will hear more about this from our next excellent speaker, Justice Jamadar, or the importance of bonding, of removing self-doubt, adding self-compassion, and of course peer support and cultivating a more community among judges. In the interest of time, I will not be able to go into greater detail, but you are all very welcome to read the full report. There are some very interesting statistics and findings which I believe every judge and every judiciary might find helpful. But I would also like to stress that the Global Judicial Integrity Network has been looking at other thematic areas as well, and you are all very welcome to read our knowledge products on gender-related issues, on the development of codes of judicial conduct, ethics training tools that we have developed, and many other tools that exactly aim at promoting experience sharing and knowledge sharing among judges and judiciaries. So with this, thank you very much for your attention, and I look forward to listening to the next presentation by Justice Jamadar. Thank you.
Joining me and assisting me is Elron Elahi. He is the Research and Programming Coordinator of the Caribbean Association of Judicial Officers, CAJO. I am Peter Jamadar. I am the chairperson of the CAJO, and I'm also a judge of the Caribbean Court of Justice. Tatiana has given us a very, very important introduction into the importance and value of judicial well-being or wellness. What we want to do now is to shift a little bit and to move into an exploration of mindful judging and the practice of intentional awareness in which has its roots in what is more popularly known as mindfulness. Judicial well-being and judicial performance exist in a symbiotic, that is a mutually beneficial relationship with mindfulness. Each one is important and both can work together to improve and enhance judicial performance. So what we want to do in the short time that we have together is to look at some research that was done in the Caribbean around mindfulness as intentional awareness. And we chat about that a little bit more in a moment, and how it has impacted judicial performance. Our core thesis is that a developed and cultivated practice of mindfulness makes for better judging and better judges. In fact, what we did in our research was we explored the impact of intentional awareness on judicial officers. In doing this, we looked at two aspects: intentionality and awareness in. And these were two core aspects of the practices that we gave to judges, and they are both very ordinary and human capacities. They can be developed and cultivated. Intentionality, when we speak about intentionality, what we are referring to is the positive and conscious intent that a judicial officer brings to bear on critical elements related to the discharge of their judicial functions. For example, the intention to be fair, the intention to treat everyone with equality. So intentionality was one core aspect of our practice. The second aspect was what we called awareness in. And this was a term that we created out of the verb form of the adjective aware and the noun awareness. Awareness in describes an active engagement of the faculty of perception that notices and participates dynamically and intrinsically in a non-judgmental and non-labeling manner with the objects of perception in the present moment. And so in that definition of awareness in, you also have our definition of mindfulness, hence mindfulness as intentional awareness in. We only have a very short time together this afternoon, and so I'm going to invite you at your leisure to have a look at our research in depth if you feel interested, and it's there at that website. But let me just tell you a little bit about the background. In 2019, about 20 judicial officers were asked to practice 2 mindfulness exercises. This was done over a 27-day period. Before they started, they completed a baseline survey, and when they were completed, they did the same survey again with some additional questions. What was quite striking for us were the changes, and that's what we want to share with you this afternoon. What and how? What we set about to do was to discover whether, if we could have judicial officers engage a practice, a mindfulness practice for 27 days to cultivate what we have called intentional awareness in. And if we could measure this in what I'll explain in a moment, 4 quadrants, could such a practice improve and enhance judicial officers' awareness in the courtroom while actively engaged in hearing court matters, and in so doing, enhance their judicial functions and performance? Now, What are these 4 quadrants that we were trying to measure? Ken Wilber, an American philosopher, speaks about dividing reality into 4 quadrants. He suggests that these quadrants are, each one of us are persons, and each one of us, in a sense, are individuals. But we each have an interior, thoughts, feelings, intentions that go on within us, including biases that we all have as humans. We all also have an exterior. You're seeing me now, my facial expressions, verbals, non-verbals, body movements. But part of reality is the collective. In the justice sector, in your courtroom, the exterior of your collective is your environment. What's in your courtroom? Where do people sit? How are they behaving? What's going on? But of course, there is also an interior to the collective. What is the ethos, culture of your judiciary, of your courtroom? So these 4 quadrants describe reality. As a judge or judicial officer, what's going on inside of you, what's going on your exterior, but also in your courtroom, what's going on as the ethos and culture of how your court runs, and then what's happening in the external environment of your courtroom. So this practice was intended to measure these 4 quadrants and the impact of mindfulness in them. Why were we trying to do that? We were trying to do that because earlier in the Caribbean, we had done some research on procedural fairness. Now, procedural fairness is something that is also spoken about as procedural justice. And basically what it says is that if certain standards of procedural fairness are met in the courtroom, it has a direct impact on public trust and confidence, it has a direct impact on compliance with court orders and reduced recidivism. And some of these elements of procedural fairness included things like parties having a meaningful voice, neutrality, respectful trust, treatment, and experiences of trust and confidence in the system, and so on. In the Caribbean, what we discovered is that these standards of procedural fairness were not being satisfactorily met. And so for us, a practical question is, well, if these procedural fairness standards had a direct impact on public trust and confidence, had a direct impact on compliance with court orders and with reduced recidivism, was there something that we could do to increase or improve these procedural fairness standards? Hence, our research into mindfulness as intentional awareness. So let's jump right in because time is limited and it's late in the afternoon and you've had a long day. What did the research show? Remember, we are trying to measure the interior of the individual and the exterior judicial officer in the courtroom. And remember, we're trying to measure what's happening not just within the individual, but in the collective, within the courtroom itself. And remember, this is important because for the court user, if they experience procedural fairness, if they feel that they are treated with respect, if they feel that they have a voice, if they feel that the judicial authority is trustworthy and is listening to them, then the indicators of public trust and confidence, compliance, and reduced recidivism increase. So, the individual interior, awareness of what thoughts you are having increased. Next, we measured, for example, awareness of what emotions are going on in you, increased. Next, we measured what about your awareness of the emotional states of others, i.e. court users, for example, attorneys, the other judicial staff in the courtroom, increases. Another metric was, what about your awareness of your own behavior? Again, after 27 days, increases in awareness of your own behavior. So let's just pause for a moment. Think about yourself as a judicial officer. Think about you in a courtroom, but think for a moment about the court users. If you are more aware of your thoughts, more aware of your emotions, more aware of the emotions of court users and other persons in the courtroom, that's the collective exterior, and if you are more generally aware of your own behavior, then maybe you could be more aware of whether or not you're being respectful, whether or not you are treating everyone with equality, and so on and so on. And so these could have direct impacts on the procedural fairness standards that we spoke about. Let's go a little further into the research. What about how aware were you and sensitive to the presence and needs of court users? Again, increases. Going further, and now this comes a little bit more to the role and function of judicial officers. To what extent could you become more aware of how you're changing emotions, behaviors, your facial expressions, tone of voice, gestures, your nonverbals, the impact on the integrity of the judicial process? And again, we found improvements. Moving along, and to make a point that I think we're all very aware of, the two core functions of judicial officers are to be finders of fact and interpreters and appliers of the law. So after this practice, were you aware or more aware of how your internal, emotional, psychological states could influence your perception, interpretation, and application of facts? Significantly, the answer after the practice was yes, increased awareness of how what's going on within us as judicial officers impacts the interpretation and application of facts. A nice nuance in the research was in the baseline survey. Some respondents said, oh, they were fully aware. And after the practice, those respondents indicated that they were actually recognizing that they were not as fully aware as they thought they were. Why is that an interesting nuance? Because what the practice showed is an increase in this phenomenon of awareness in that when they thought they were as fully aware as they believed they were, in fact, they were not so. So let's move quickly. We spoke about awareness, increased awareness in relation to facts, also increased awareness in terms of perception, interpretation, and application of the law and how what's going on in a judicial officer, that the internal states can impact this. So, as I said earlier, the research shows that judicial officers can, through the cultivation of mindfulness as intentional awareness in, become more aware, increasingly aware of how their own internal mental, emotional, and psychological states can influence their perceptions, interpretations, and applications of both facts and law. These are core judicial functions and go directly to judicial performance. As we end this session, and this is just really a little glimpse, a little sort of aperitif, a little taste of the research. How has mindfulness, intentional awareness, and impacted my own performance as a judicial officer? I've been a judicial officer for over 26 years, sitting in the High Court, then in the Court of Appeal, and now in the Apex Court in the Caribbean Court of Justice. And I'll tell you just one little example of how it's made a difference. Being more mindful, being more intentionally aware of what's happening within me, about how I present as a judicial officer and what's happening in my courtroom, has really made me more attuned, for example, to court users. A simple thing. Aware of what's happening in the courtroom, I recognize a court user who is fidgety and can say to their attorney, you know, I think maybe you need to just have a chat with your client. I think maybe they want to say something or something is going on. And that simple intervention can have a significant impact on how a matter progresses, including even opportunities for settlement. And that's because I'm more aware of what's happening. Another thing, a witness comes or a lawyer comes, and as judicial officers, we're all aware, I hope, that there are certain attorneys, when they walk into a courtroom, we are just triggered. Why is that? Because to be human is to be biased. Unconscious bias is simply part of what it means to be human. But if we're not aware of our biases, of the stereotypes we carry, of the assumptions we have, then we can actually uncritically make assessments of fact, decisions about law that are unjust. What mindfulness, as intentional awareness has done for me, is helped me become very sensitive to those internal triggers. You remember the Ken Wilber 4 quadrants? The interior of the individual and the exterior. Becoming more aware doesn't mean that I am not biased. Of course I am biased. That will never change. But I am aware of my bias and can mitigate it in court, in real time, and strive to be more fair and more equal. So this is just, as I said, very quick introduction to the research to share with you. If you want to find out more, please go on our webpage, https://betterinjustice.com. You'll find the research there and a lot of other interesting stuff. But I do want to say that consciously cultivating a practice such as mindfulness, as we have tested it, intentional awareness in, can not only enhance your well-being that Tatiana spoke to, because mindfulness has several impacts on well-being: stress reduction, mental health improvements, enhanced cognitive functions, sleeping better, physical health benefits, but also enhanced self-awareness, which our research has corroborated, and something called emotional regulation. These lead to better decision-making and healthier interpersonal relationships. As judicial officers in our courtrooms, we cannot forget the interpersonal, relational dimension of the work we do. And maybe we can be more compassionate, more humble, more sensitive, and performance can improve, public trust and confidence can improve, and the delivery of justice that we are responsible for can make a difference in real people's lives in real time. Thank you, Elron, for the support. Thank you, Tatiana. Thank you all, and I wish you the best for the rest of your conference.
I would like to thank you, dear Justice Rajamadar, for joining us today. I know it's very early for you, so we really appreciate your time and your insightful and powerful presentation. I'm aware that we're nearly at the end of this session, but I would nevertheless like to open the floor briefly for possible questions, but also importantly comments, because we strongly believe that on this topic what is lacking is discussion and experience sharing. So we would be also delighted to hear from you, dear judges, how your experiences are, what type of support you might need, and if you have any advice or recommendations to your fellow judges from your work and life as judges. So please, the floor is open. Okay, it seems like there are no questions and comments at this stage, but nevertheless, thank you again for your attention.
So, thank you, Ms. Tatiana Veres. Thank you, Ms. Tatiana Veres and Justice Peter Yamada for your valuable insights and contributions to this session. Ladies and gentlemen, as we draw close to the end of day one, I'd like to take a moment to express our appreciation for your active participation and engagement throughout the day. Your presence and insights have made this event truly remarkable. But before we conclude for the day, we have a special guest. It is an honor to introduce the Honourable Michael Kirby, ACCMG, former Justice of the High Court of Australia, who will share some closing remarks with us. Please, Justice.
Well, thank you very much for having me at your conference. I wish I were up there in Bangkok. It would be a whole lot better than being down here in Sydney and at the end of a very long day all of you are going to be tired and you're not going to be waiting for comments of mine. My relevance, however, is that I was present at the creation. I was participating in the Judicial Integrity Group, and the Judicial Integrity Group ultimately led on to the Global Judicial Integrity Network. These two bodies still exist, they cooperate, and many of the principles that have been accepted by the network have come out of the work of the Judicial Integrity Group and its judicial integrity principles, the principles of judicial conduct, which were adopted in 2001. It's important to realise that the principles of judicial conduct, the Bangalore principles of judicial conduct, grew out of an idea which had been promoted by Transparency International. Transparency International, as you would know, is established in Berlin. It carries out global surveys and investigations of corruption, corruption of officials, and also corruption in the judiciary and in the staff of judiciary. So it was that concept in the organization known as Transparency International that led to the establishment of the group, the Judicial Integrity Group, who formulated the principles of judicial conduct. And I had the privilege to be at the early meetings and have been participating with the Judicial Integrity Group ever since. The actual principles were drafted in 2001, and the greater part of the drafting fell to Dr. Nihal Jaiwikrama, who was then associated with Transparency International and who had been the Secretary of Justice in Ceylon. And I knew him in those very early days, and he had held various other positions in the administration in Sri Lanka. The principles were adopted at meetings that were held, including in the Peace Palace, and the chair of the Judicial Integrity Group was Justice Weeramantry, Christopher Weeramantry, a distinguished former judge of the Supreme Court of Ceylon, and a very able judge of the International Court, and later the vice president of that court. And Justice Bhagwati, former Chief Justice of India, was present at the time, and Dr. Param Kumaraswamy, Dato Param Kumaraswamy of Malaysia, who became the United Nations Special Rapporteur on the judiciary and the rights of the judicial, the role of the judiciary and lawyers. He was an active participant. So you'll see that a very large part of the work of the Judicial Integrity Group was performed and inspired by judges and lawyers from the Asian continent. And it's the role of the lawyers like Weeramantry from Sri Lanka, Bhagwati, former Chief Justice of India, Nihal Jaiwikrama from Sri Lanka, and Param, Dato Param from Malaysia, and 8 Chief Justices from English-speaking countries were the early participants, but the work of the group was tested at meetings that were held in the Peace Palace, where Justice Weeramantry was able to take us into the inner sanctum of the judges of the International Court of Justice. And out of these meetings and out of the consultation with people from a very different legal tradition than the tradition of the common law, came the Bangalore Principles. And those principles, as you know, have certain fundamental core principles, and a commentary has developed around the principles which sets out an explanation of the core principles and of the application of the core principles in day-to-day practice. And all of this was developed from a huge amount of work in countries right around the world that Dr. Nihal Jawik Rama encapsulated and synthesized and were adopted by the Judicial Integrity Group and recommended ultimately to the Global Judicial Integrity Network. And the Global Integrity Principles have been extremely influential. The fundamental or core principles of judicial integrity set out in the Bangalore Principles are 6: independence, impartiality, integrity, propriety, equality in treatment, and competence and diligence. These fundamental principles are referred to and elaborated in various international treaties and statements of principle, and they are the core principles of the Bangalore list. It's interesting to note that when we got to the Peace Palace and were sitting down with judges of the civil law tradition, the civilians, we found that overwhelmingly we shared common views about the fundamentals of the judicial integrity. There were some principles that were different. In some countries, judges must, in effect, become associated with political parties. And in English-speaking countries, that is definitely prohibited. So these were some differences, but overwhelmingly, the deep principles were found to be common of common law countries and civil law countries and others. And the Judicial Integrity Group and later the network met in Doha, in Vienna, in Garmisch-Partenkirchen in Germany, and they decided that they would face the reality that we couldn't have expressed all of the principles that would last forever without modification or elaboration. And so we turned to the question of whether there should be modifications and how we would go about developing them. And I think this is an issue that both the Judicial Integrity Group, which continues to exist and is inspired by Judge Mellinghoff, Rudolf Mellinghoff, a former judge of the Constitutional Court of Germany and now a Chief Justice of the Finance Court of Germany, and of Nihal Jawik Rama. They have been the leading spirits of the Judicial Integrity Group, and they turned their attention, as did I, as the rapporteur of the Judicial Integrity Group, into how we could find a way to elaborate where that was shown to be necessary. And as a result of those discussions, I prepared a document which I will send to your secretariat tomorrow, and that document can be made available to the participants in your conference. And in that document, I propounded 2 additional principles. There was some resistance to having additional principles because the judicial integrity principles had themselves been adopted by ECOSOC and by the UN General Assembly, and therefore there are reasons for sticking as long as you can to the principles that have been adopted by those high bodies of the United Nations. But at the invitation of my colleagues, I suggested that there were 2 additional principles that perhaps should be added to the 6 core principles. And I sought to argue for this in the document which I will send to you and which was sent to the network and to the Judicial Integrity Group. The first was the principle of courage. And I was interested to see in the last session with Justice Vares and Justice Jamadar, the emphasis placed on leadership. And leadership requires courage and insight. All of us who have been in the judiciary will know that some colleagues sometimes are very cautious and very disinclined to develop or expand principles of law, even in the case where injustice will otherwise occur. A very important case in Australia demonstrated this to my mind, and that was the Mabo decision. The Mabo decision was a decision of the High Court of Australia, the highest constitutional and appellate court that I was later to join and had the honour to be a member of. And the case of Mabo faced the reality that in Australia, virtually from the beginning of colonial settlement, the rights of the indigenous people were ignored. Their land rights were denied. They were not respected in the law. And the consequence has been the economic disenfranchisement of most First Nations people. And the matter came up for consideration in the High Court of Australia. And it would have been very easy for the judges of that court to say no. It was a century and a half of a settled law. It was a matter of political controversy. It was a matter in which some social science and other research could have been useful in deciding what should happen, and so on. I could write that decision in 20 minutes. It would be an easy decision to write. However, the majority of the court, 6 of the 7 justices, decided to take a different path. And that was because, in my view, of courage. They looked at the issue, they looked at the principles of international human rights law, and they came to the conclusion that they shouldn't just give a tick to the old principles of law. They should think of those old principles, when they came, how they came, and whether they were still relevant to our country today. They showed courage. And other cases came up, including during my time on the High Court of Australia, where, especially in relation to the Indigenous people, but right across the spectrum, there were cases which called for courage. And in some of those cases, action by the judges was essential. And ultimately, in some cases, it was found in the judicial branch. But in many cases, judges simply took a formalistic path. They said, these are matters for the judiciary. These are matters where the judges should not intrude. These have a political dimension, and we should not do anything about it. And every one of us, judges in Bangkok and judges in Australia and around the world, know of colleagues who are inclined generally to take that course. But in the Mabo case and in later cases, some of which I took part in, courage was found as an essential attribute of judges applying the principles of independence, integrity, impartiality, etc. And so what is being considered at the moment is whether there should be a 7th principle, which is courage. What does it matter if judges have independence and formal propriety and competence and so on? If they don't have courage, where courage is called forth and where leadership is required. I saw an example of this morning in a decision which came across my desk. So, as Fox News says, this is breaking news. This was a decision yesterday. It was a decision of the Supreme Court of Mauritius. It was a decision in which that court reached a unanimous view. And the question was whether the provisions of the Mauritius Constitution forbidding discrimination adverse to people on any ground could be brought into play in responding to the request of litigants who were LGBTIQ and who were asking that the old colonial laws criminalising gay people should be struck down and held unconstitutional, against the constitutional mandate of the Bill of Rights in the Constitution of Mauritius. And the court unanimously held that it should be struck down, that it was not something that came out of the people of Mauritius, was something imposed by the colonial period, and it had outlived its relevance and should be removed because it was seriously discriminatory against gay people. And the judges said a very interesting thing. I've never heard this said. There are many such cases now in many countries, Belize and Botswana, the great Supreme Court of India decision, and others, finding the same solution to the LGBTIQ issue. There are many such cases, but the judges in Mauritius gave an explanation of why they would not accede to the suggestion that this was a matter for the parliament and not for the judiciary. And the answer they gave was that the principle of the separation of powers, which is a fundamental principle of constitutional law, applied to ensure that Parliament did not intrude into the judicial branch and that the judicial branch did not intrude unnecessarily into the parliamentary branch, that both of them respected the other, but each of them had a separate and different role. The judiciary had the separate and different role of applying the Bill of Rights of the Constitution, or the principles of fundamental human rights, and that this was a part of the principle of separation of powers. And so, applying the matter in that way, they said, the Parliament does its job, we do our job, and our job is one that the Parliament cannot intrude into and prevent us from discharging our responsibilities. And so, the 180-year-old legal principle inherited from Britain, abolished in Britain 60 years ago, was swept aside in Mauritius by a decision made yesterday. And that's why I think courage is an important element in the work of judges. And they have to try to find it in themselves and in their professional life and professional duties, not to be merely formalistic, but to examine the case and to look at it as judges and to reach conclusions which respect the dignity of all people and is not guilty of discrimination. Another principle that was being considered was empathy, and a further principle was non-political stance, because we've had a rather unfortunate case in Australia where judges of a tribunal were appointed, all of them overwhelmingly from one political side, and that did affect the decisions of the Administrative Appeals Tribunal, which is now being replaced. So courage and empathy for people who are disadvantaged, and non-party political principles were important new ideas for adoption to add to the judicial integrity principles of the Bangalore Principles, which were formulated in 2001. So that is what I came to tell you. The principles of integrity are never finally closed. Our knowledge as human beings and as judges continues to expand. As I've always made clear, certainly in recent years in Australia, I myself am a member of the LGBTIQ minority. I've been living with my partner in Australia for 54 years, and he's here tonight waiting for me to finish this address. But you can't allow your personal biases to control your decisions, but you can insist, particularly for minorities, that all minorities will be treated in accordance with universal human rights, and none of them will be excluded from the protection of the judiciary and judges who conform to the universal principles of human rights and to the Bangalore Principles on Judicial Integrity. Thank you for having me in your session tonight, and I hope that there will be further discussion, not only of the old form of the judicial integrity principles, but also for revising them, improving them, and drawing on our experience as judges in busy courts, working hard to make decisions according to law, but also according to deep principles that require the respect for the principles of human rights and the Bangalore Principles. Thank you for having me in your session.